Welcome to Monthly Metz with Keith Metz.
Welcome to the Monthly Metz with Keith Metz, founder of the Metz Law Firm in North Carolina. Keith focuses on DWI, traffic violations, and misdemeanor criminal defense, helping people navigate charges that can affect their license, their record, and their future. With experience inside the district attorney's office, he understands how these cases are built and how to approach them strategically. I'm Lisa Mosby, your host, and today we're talking about what really happens after a first DWI in North Carolina, including license consequences and whether a case can even be dismissed. Welcome, Keith. Thanks so much for joining me today.
Thank you.
Before we get into the process itself, can you share a little bit about your background and how you came to focus on DWI in district court cases in North Carolina?
Absolutely. So I opened my law practice in August of 2015. So we're pushing 11 years now at this point. And when I first opened the practice, I originally started practicing in family law before I very quickly realized that I did not like family law and moved my practice over from family law into more of a traffic approach, mainly just handling speeding tickets, things like that, no operator's license, helping people, clients get their license reinstated. Which when you start handling traffic cases, you very quickly somehow get adjusted into doing DWI work. Eventually you get that phone call where somebody who's got a DWI, I had some colleagues that did it, and they started kind of helping me through the ropes on things at that point in time that I need to look out for. I attended some seminars and some very special continuing education courses, which eventually kind of led me down to the path and a heavy focus on DWIs.
And, there's different acronyms. DWI is North Carolina, but other states use different acronyms like DUI or other things. Let's start at the very beginning. Someone is arrested for the first time with a DWI. What is it? And what happens in the first 24 to 48 hours after the arrest?
So DWI stands for driving while impaired. You're correct. In other states, it might be referred to as DUI or driving under the influence. Effectively, they are exactly the same thing. Different states have different names for them, but it's either going to be DWI or DUI. In North Carolina, it is DWI or driving while impaired. This can be impaired from alcohol, or it could be impaired for marijuana or any other impairing substances, including legal drugs that you might be prescribed. So those can impact you as well. As far as what happens within the first 24 hours, so if an officer stops you, let's say for speeding, and during the course of the officer's investigation, the officer has reason to believe that you are impaired. Maybe he smells alcohol in your breath. Maybe you're slurring your speech. Maybe a combination of all of the above. The officer will get you out of the car. We'll start running field sobriety tests on you, and then we'll make a decision as to whether to arrest you for that DWI. Now, if you are alcohol impaired, that is to say that you don't have any drugs in your system other than alcohol, and it is an alcohol DWI investigation, the officer will, after arresting you, will take you to the police station where they will run an Intox on you. Intox is just a fancy word for breathalyzer. It's a very special breathalyzer that is checked, I believe, monthly by the state of North Carolina. It is recalibrated to make sure that the breath samples that are going into it are accurate. If you blow a 0.08 or greater, your license is going to be automatically suspended for 30 days. Doesn't matter that you've not been convicted of a DWI yet. That is the law in the state of North Carolina, 30 days. After 30 days, you can go to the clerk of court in the county where you got your license, in the county where you got your DWI from, and you pay them $100. You get your driver's license back. You also realistically, depending upon how impaired you are, will sort of determine when they let you out of custody. If you are extremely impaired, you might sit in custody for several hours while you sober up before they'll release you back into the world. If you're minorly impaired, maybe you're 0.08, 0.10, or something like that, lower levels impaired. Typically speaking, by the time you're done with your Intox, you're done with their investigation, you will be usually given a bond. Generally speaking, it is a written promise to appear in court, and you'll be released from custody at that point in time. Your next step immediately after that should be calling a lawyer.
And you mentioned that they take the driver's license right away. Is that always the case, even for a first-time DWI in North Carolina?
That's a trick question. So it is almost always the case. The rule of thumb on this is if you blow 0.08 or greater. If, say, you blow it Intox of 0.07, they might still charge you and prosecute you for that DWI, even at a 0.07. But because you're not in excess of that 0.08, they're not going to take your license immediately. It is not automatically suspended for those 30 days. Likewise, in cases where there is a blood draw, you'll often see this in cases where there's been a car wreck and they got to take you to the hospital. In cases where there is a blood draw, blood takes a long time to come back. They don't have the results back immediately like you would at the Intox. So with blood, you're sometimes waiting 3, 6, 9, 12 months. I've waited 18 months for one client's case for blood work to come back. And so because it takes that long for blood work to come back, you don't have an instant BAC, which means your license is not automatically suspended on the spot. But if that blood work comes back with a 0.08 or greater, whenever it does come back, at that point in time, that gets registered with the clerk of court, who then registers that with the North Carolina DMV. And then you will receive a letter from the DMV telling you that your license is suspended for 30 days. That letter is going to provide you instructions on how to turn your driver's license in.
And then the other thing that you had mentioned in the beginning is prescribed medicine, that you can get in trouble while driving under the influence of prescription medicine. Let's talk a little bit about that. That's new to me. I wasn't aware of that. How do they test for that, or how do they know?
So that is going to lead the officer down a drugged impaired approach. This is a little bit different. So let's use the example that I used before of speeding again. So they stop you, say, for speeding. And during the officer's investigation of you, the officer hears maybe you've got slurred speech. Maybe he's asking where you're coming and going from, and you're just not making much sense. Typically in scenarios like this, it's not usually from a specific traffic stop. It's usually we're dealing with drugged impaired. A lot of times it's people that are falling asleep behind the wheel, sometimes in the middle of in the traffic lane. So that automatically will make the officer's spidey senses tingle about what's going on here. And if they're not smelling alcohol on you, but they have other reasons to believe that you're impaired, that is going to lead them down a very specific approach to doing a drug impaired investigation on you. For that, they have very specialized officers. They're called DREs, or drug recognition experts, who have to do a full panel on you. There are several more standardized field sobriety testing for drugs than there are for alcohol. Even they will also run blood work. They will also bring you to the hospital. Obviously, if you are on prescribed medication, it's not something you can blow into a breathalyzer for or an Intox for. So what they will do is they will bring you to the hospital. They'll have a blood draw done. And at that point, then you're just waiting on the blood work to come back to confirm what's in your system. Now, obviously, if the blood work comes back, there's nothing in your system, they're not going to be able to prosecute you. But if it does come back with something in your system, even if it is a prescribed drug, even if it is in the amount prescribed, you can still be charged and convicted of a DWI. That driving while impaired applies to everyone, that even if you are completely unintentionally impaired because you're just taking the medicine that your doctor prescribed you, you cannot be appreciably impaired while driving in the state of North Carolina.
Thank you for the clarity, because that's something new to me. So I imagine some of our listeners have not heard of that before. Is there a difference between the immediate civil license consequences and what the criminal court process might ultimately decide?
Yes, there is. That civil revocation, again, that's just that 30 days, that it's automatic if you blow a 0.08. Now, we have to distinguish that from an actual conviction, because you might blow a 0.08 and you might take the case to a trial. And if the officer did not establish a proper investigation beforehand, say he didn't do the field sobriety testing with you, he didn't have enough evidence to have arrested you, then the state's going to have a very difficult time convicting you. So there are certain challenges that you can make at a trial level where you might beat the DWI and not be convicted, but because you blew a .08, that civil revocation is still going to come in the first place. Again, it's going to only be for 30 days, and after 30 days, you can get your driver's license back.
Okay. And Keith, you've worked inside the district attorney's office before. From your perspective, what factors tend to matter most in how first DWI cases move forward?
So my time in the DA's office was with the Union County District Attorney's Office. My office is in Mecklenburg, but I do still take cases out in Union. That was while I was in law school. So it was my third year in law school, the final year of law school. I spent about a year interning with their DA's office. Specifically to answer that question, there really aren't any specific factors of what they're looking for. DA's offices in the state of North Carolina kind of prosecute DWIs very all in the same way. We have 100 counties in the state of North Carolina. There's almost 100 different DA's offices. There are certain districts where the DA controls more than one county. But the consensus among them all is the same. They prosecute DWIs to the fullest extent of the law. They don't regularly negotiate these. They don't reduce them. Even if it's a weak case, they will still proceed on them. Here's why. DWI is a very political thing, and the elected district attorney wants to win his or her reelection. And Mothers Against Drunk Driving, more commonly known as MADD, has a stranglehold on the district attorney's offices in this state. So if a particular elected district attorney suddenly changes their office policy to say maybe go a little bit weaker on prosecuting DWIs, MADD will be storming their office with pitchforks and will be very strongly funding anyone who's willing to challenge that DA when he or her are up for their reelection. So because of politics, what the DA's office tends to want to do is we're not reducing anything, we're not negotiating anything. Your options are going to be plead guilty or plead not guilty and take the case to a trial. They would prefer to leave even the weakest cases in the full discretion of the judge. So the process for the DA's office is, at least in the counties that I'm in, Mecklenburg, Gaston, Cabarrus, and Union, though I used to practice in Rowan and Iredell as well, it's all the same. It is full steam ahead. We're moving forward with this case. And if you don't want to plead guilty, that's fine. You can plead not guilty. We'll take this case to a trial.
And Keith, for someone facing a first DWI right now, what are the most important things to focus on early in the case to protect their license and their long-term record?
I think a big thing is trying to remember the events that occurred when they occurred. It helps firstly in being able to explain everything to a lawyer. So step one is going to need to be contacting an attorney. I do not recommend going about handling a DWI on your own. Even if you think you were completely sober, you should absolutely call a lawyer. But trying to recall, even writing down everything that you can recall, helps a lawyer in their own investigation of things. It lets us queue up, say, when we get video footage back from the DA's office, when we get body camera or dash camera footage back, it lets us hone in on what we need to look at. Okay, my client is telling me that he was asked this at this point in time. Let's confirm, first of all, is that true? Are you remembering that correctly? And if it is true, is it something that can help the case? Is it something that hurts the case? So trying to be able to remember all the events as they occurred, when they occurred, is, I think, an incredibly important step, in addition to, of course, hiring a lawyer.
And then are there some other behaviors that you might want to, I don't know if I can use the word advise, but actually warn people about, on the scene? Are there certain things that we should or shouldn't do at that time?
The answer to that question is it depends. And I hate to sound like a cliche lawyer, but it does depend. So what should be done, what should not be done? I think the one thing that applies to everybody is, as frustrating as it is, as embarrassing as it may be, cooperate with the officer. I don't care if the officer is being rude. I don't care if the officer is acting like they're your best friend. Cooperate with the officer. It will go a long way in both defending you, and if this video has to be aired in front of a judge, in front of a jury, It just makes you look better if you're being cooperative. I think that applies to everybody. As far as other steps that should be taken, you have a few different options when it comes to a DWI investigation. So same scenario, you're speeding, officer pulls you over for speeding, smells alcohol in your breath, asks you to get out of the car. The officer is going to ask you usually to do what they call a battery of standardized field sobriety testing. And we've all seen these. You see them on TV. They're going to do horizontal gaze nystagmus test. That's where the officer is going to put his finger in front of your face, move it from side to side. The other test they're always going to do is going to be the walk and turn test. And then finally, the one leg stand test. So you do have the option here simply to refuse to take that test. You don't have to do any of them. You can be pulled over. The officer can say, hey, I smell alcohol in your breath. Do you mind doing some field sobriety testing? And you can say no, but I will allow you to arrest me and take me to the police station. I'm willing to blow into an intoxilizer. So you can, sometimes it's beneficial to do that. If you are maybe not particularly fit, not very well coordinated, and you know that you are either at least not impaired, but preferably below the legal limit, that can be incredibly helpful to you because the evidence that they gather from you doing standardized field sobriety tests can sometimes be harmful. So if you go about not providing them with any information and then you blow, and let's say you blow 0.08 or preferably below that, it really helps your case out if you didn't provide them any extra evidence for the state to hang you with. That being said, it's not always the best to avoid doing field sobriety tests. Sometimes it is better. When the officer is conducting these field sobriety tests with you, what they are looking for is probable cause. In other words, does the officer have enough information to arrest you for DWI? The officer doesn't know what your BAC is yet. That comes on later. But what they're looking for is there enough information here? The officer have enough to arrest you for the DWI? And sometimes if you can perform well enough in those field sobriety tests, then the officer might not arrest you. You might be able to walk, or they might still arrest you, but hiring an attorney will be helpful because then we can look at what your performance looks like, and we can assess how well you did. Also, as it pertains to the field sobriety test, officers often screw these up. They are called standardized field sobriety tests. It means they're supposed to be conducted exactly the same way every single time, regardless of who the officer is who's conducting them, and regardless of who the driver is that they're conducting them on. So if the officer misses instructions or doesn't provide you with certain instructions or doesn't demonstrate something correctly, that gives us grounds to throw that particular test out. I mentioned that there were 3 ways you can go about doing this. So skipping the field sobriety test and going straight to the Intox is one. Another is you can do the field sobriety test, and then if the officer arrests you, you can go to the Intox and you can refuse. Refusal becomes a problem sometimes. Sometimes it's helpful, sometimes it's extremely hurtful. First of all, if you refuse, your license is going to automatically be suspended from the DMV for 1 year. No matter what, doesn't matter if you're convicted or not, you are suspended for 1 year. You are not eligible for a limited driving privilege for at least 6 months into that year. So it just means you can't drive for 6 months. It becomes very hurtful for a lot of people. And sometimes, usually, even if you do refuse, the officer can go get a warrant for your blood and still get a blood draw out of you, which means even if you refused, you might still get a BAC. So your license is suspended for a year and we still get a BAC out of it. So this I usually don't recommend. There are circumstances that I have seen in my own practice where it has been helpful, but I think usually overall it tends to be more hurtful. The third method is going to be you can simply refuse to do any standardized field sobriety testing, and of course they arrest you, and then you can refuse anything at the Intox. Likewise, that's going to suspend your driver's license for a year, but it gives them the least amount of evidence against you, assuming they don't get a warrant for blood.
Very good. Well, thank you so much for the clarity and for your insights today, Keith. That's it for today's episode of The Monthly Metz. If you'd like to learn more about Keith Metz and his work at the Metz Law Firm, visit keithmetzlaw.com. If you're facing a DWI or traffic charge in North Carolina, getting clear information early can make a real difference. Thank you for listening, and don't forget to like, subscribe, and leave a review if you found this episode helpful. And we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.